Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Tomorrow's my last day out of town, hopefully for a little bit, but I'm going to be off camera a couple more times until I get home. I just wanted to go over an update in the Justin Baldoni versus Blake Lively case that just came out on the docket. We have a response from Justin Baldoni and the Wayfarer parties to Blake Lively's motion to strike. Blake Lively had filed a motion to strike an exhibit which held her deposition transcript from the record. They claimed it was a rough transcript, and then they went off on their tangent again about how the Wayfarer parties are trying to make her deposition a media spectacle, even though she was granted permission to have it in her location of her choosing. And it seems like her team leaked any and all information that came out about that. But, facts don't matter here. And let's face it, both sides are playing it aggressive with the PR approach at this point, and Blake's side is failing miserably. When you're a higher profile celebrity, you have to play to the court and to the court of public opinion, and she's not doing very well right now with the public. So of course she makes a show out of Wayfarer, including the deposition and an exhibit, leaving out all context. I have heard mixed reviews on this from attorneys and people who are familiar with the legal process as far as whether or not this is like normal or acceptable. I've gotten a mixed bag. Some say yes, some say no. So I'm not really sure, to be honest, and I'm not gonna not gonna really give you a yes or no answer because I don't know. But we'll take a look at what Kevin Fritz had to say on behalf of Justin and the Wayfarer parties in response to that motion to strike here. Dear Judge Lyman, we write in opposition to Blake Lively's motion to strike her final deposition transcript, currently filed under seal from the docket and for related relief. So right away we have a discrepancy here. They say it's a final deposition transcript, while Blake's attorneys say it was a rough transcript. Ms. Lively frames her argument as a motion to strike pursuant to Federal Rule of Civil Procedure at 12F and the court's inherent power. However, Rule 12F does not authorize this court to strike documents other than pleadings. Pleadings include only the complaint, answer to cross-claims and counterclaims, third-party complaint, answer to third-party complaint, and replies when ordered by the court. They do not include exhibits submitted in connection with oppositions to motions. And then they're citing Judge Lyman here, denying motion to strike opposition to motion to dismiss as procedurally improper. They've been citing Judge Lyman a lot lately, who of course is presiding over this case. Further, Ms. Lively does not contend that the deposition transcript contains abusive, improper, or libelous materials, which might warrant the court's exercise of its inherent power. After all, the deposition transcript records Ms. Lively's own words. Ms. Lively contends that the transcript must be stricken based on her speculation that it was filed for the purpose of the transcript into the public domain as fodder for their media campaign. The transcript, however, was filed under seal, and Ms. Lively has the option of moving to keep the document sealed. Although it is puzzling why she seeks to conceal her own testimony in an action in which she is the plaintiff. And then there's a footnote 1 here. It says, we are unclear why Ms. Lively refers to her deposition transcript as a rough draft, given that the document is not marked as a rough draft, as such versions of transcripts traditionally are. The deposition transcript was filed in connection with Liner Friedman, Tatelman, and Cooley LLP's motion to quash Ms. Lively's subpoena, seeking Brian Friedman's purported statements to content creators in the media. Liner Friedman moved to quash the subpoena, which motion has since been largely granted. The parties fully briefed the issues, and on July 30th, 2025, the court heard oral argument. No additional argument or supplemental briefing was requested by the court. Nonetheless, Ms. Lively filed a letter with the court, which purported to address certain questions with the court, but which was truly an improper submission of further argument on the motion to quash. So, as you guys probably remember, they came out with that letter a little bit after the hearing. It alludes to the interview between Megyn Kelly and Brian Friedman after most of the Wayfarer party's claims were tossed out with prejudice by the judge. And it's clear that they implied Brian Friedman and Megyn Kelly said things they didn't exactly say. Brian Friedman didn't say the things they were complaining about at all, and Megyn Kelly was not speaking in a first-person sense. She was referring to how the public viewed Blake Lively after her public relations disasters. The Wayfarer parties responded, citing Ms. Lively's deposition transcript, which was attached as an exhibit, to demonstrate for the court that Ms. Lively's allegations of an ongoing smear campaign are unsubstantiated. By improperly submitting additional argument on the motion to quash, Ms. Lively invited a response that would include evidence to establish the true reason why Ms. Lively served the subpoena upon Liner Friedman. It is routine for the court to consider deposition testimony in connection with discovery disputes. And remember, what they said in that response was that Ms. Lively's only purported evidence of the smear campaign at this point had something to do with Brian Friedman acting on behalf of Wayfarer in regards to their counterclaims. which they say is not a smear campaign. It was part of a lawsuit. So she kind of set herself up with this one when she sent that letter accusing Brian Friedman again after the hearing, further accusing him of being part of a smear campaign. And then she said in her deposition that there's no real evidence that she has of a smear campaign other than Brian defending his clients on their counterclaim. What a dumbass. Contrary to Miss Lively's contention, the Wayfarer parties did not hope to make her defend the continued sealing of the transcript so they can advance a false narrative that she is afraid of her deposition testimony becoming public. Miss Lively will either move to permanently seal her transcript or she will not. The choice is hers. Miss Lively next alleges that it also appears the Wayfarer defendants immediately leaked details from the deposition to the tabloid media. She does not cite any evidence. This is not surprising, as there is none. Miss Lively also fails to explain why any such leak could not have originated from Miss Lively, her husband, her multiple attorneys, 8 if I remember correctly, legal or administrative staff from the law firm representing her, whose office she demanded host the deposition, or the catering staff employed thereby who served lunch. Putting aside the identity of the culprit, the identities of those in attendance for her deposition are not newsworthy, because all parties are entitled to attend all depositions. For the reasons set forth above, the motion should be denied. Look, this is not the first time she's come out and said the Wayfarer parties told this to the press, they leaked this to the press, and there's no evidence to explain that whatsoever. Anybody could have leaked that to the tabloids. Dozens of people. Their credibility is shot at this point. All right, guys, that's all I got for right now, but thanks for watching, and I'll keep an eye out for any updates tomorrow. Like I said, I'm still out of town tomorrow. It's my last day out of town, so I will try to keep up, though. So thanks, everybody, and I'll see you all soon.